Hello, everybody. Hello. Welcome to Subscriber Sunday. Hello. Welcome in, everybody. Hello. Good to see you all. I do sub chat only once a week, everybody, on Sunday evenings. Just as a very special thank you to all of my subscribers. So that's what we're doing tonight. Hello. Hi, Sue. It's good to see you. Hello. Boy, we got a lot going on in the world right now. We've got a lot. Oh, hi from chilly Chicago. Oh my goodness. Ooh, the Windy City. Yes, indeed. I hope you're able to see some sunshine. It's been pretty bad recently, I know. I miss the sun, everybody. I miss it. We need the sunshine to come back. For those of us who are in the central central time zone, we need that sun to come back. Hello. Hi, Steffi. Good to see you. Hello. Good evening. Hello. Good day. Welcome in, everybody. This is my special sub chat only on Sundays, where I have comments just for my subscribers as a special thank you, but of course do a presentation for everybody. So tonight, everyone, we need to talk, I think, a little bit about Florida. Florida's getting a little bit crazy. We're getting a North Star on Tuesday. Oh, exciting. That's very exciting. Oh, I love to hear it. Sis, congrats. Love to hear it. So everybody, we've got a lot. We've got a lot going on. Just to give you a general overview before I dive into an update out of the Florida documents case, everybody. Yeah, the judge. I know. We got to talk about the judge. We got to talk about recusals. We're gonna hit the whole thing tonight. But just keep in mind, tomorrow is the deadline for Mr. Trump to file his appeal on the immunity decision out of the Court of Appeals for the DC Circuit. So that's tomorrow, everyone. We will find out whether or not Mr. Trump is going to file that appeal. It is due tomorrow. So that's pretty big news. We also have another hearing too. We've got the Blessing Game case. If everyone remembers, that's the lawsuit, the Capitol Police lawsuit against Mr. Trump for his actions on January 6th. It was this case that came, this idea of, was Mr. Trump acting as a candidate, Trump, or as a president? And at the time on January 6th. So we've got some paperwork that needs to be filed for a SCOTUS opportunity then that's due this Thursday as well. Nor'easter. Oh my gosh, I was going to say, well, are you happy about that? Okay. Oh my goodness, Suze. I hope you'll be all right. Oh my gosh. Make sure you get lots of chopping up the wood and batten down the hatches. Oh my goodness, that's so funny. Oh my gosh. All right. So we got the Blessing Game filings that need to be done on Thursday. We also have the omnibus hearing for the New York criminal case. So this is the fraud money, hush money case, the campaign fraud money case out of New York, one of our 4 criminal cases. Yes, and gas. Oh my gosh. Oh, I know it. Yikes. I don't know what I'm going to do if another big storm comes through, everybody. I don't know if I can handle it. That was my cat. So we've got that coming up on Thursday. We also have the disqualification hearing regarding Miss Fani Willis out of the Georgia case. That hearing has been set by Judge McAfee on the 15th. So far, it looks like it's still going to go. And that was my cat again. I apologize. So we will see if it's still going to go on the 15th or not. So we've got a lot going on, but really we need to focus on Florida. Florida's got some big questions with what is going on. We also have not heard from Judge Engoron yet, everybody. So for those who have been following, Judge Engoron had thought he would be able to get his judicial opinion done by the last couple of days in January. And, that didn't happen. So we've had some questions, we've had some emails and some filings that have gone back and forth. So just to give everybody a heads up. I will be going through all of the filings regarding Judge Engeron. That will be tomorrow. So I will do that tomorrow at 7 for my live at that time. So we do have a few filings there, filings and letters back and forth and emails. So that'll be the New York civil case. We still don't have a decision yet. We should get it pretty soon. But we will see what happens. But I will be going through all of that tomorrow because that's kind of a big deal. But for tonight, everyone, with that, tonight, let's talk about Florida. Let's dive right into Florida. We got stuff going on in Florida, everybody. So, I'm trying to remember where we were when last we spoke of Florida. These judges are killing me. Oh, I know. We got some issues going on. We've got some issues. So let me bump this up just a little bit so you can get a better view. So this is the docket for the Florida case, everybody. All right. So for anyone who is interested in all of the filings for the Florida case, it is available online. You can look these up yourself as well and pull them and take a peek for yourself. This is US v. Trump. This is the Florida case number up here, and then they have the docket written out. Now, this is Court Listener. I've only got the docket printed from November because we really need to focus on what has just happened with this case. It's kind of a mess. I think Judge Cannon's really kind of twisted herself up here into a bit of a pickle with her latest rulings. So we've got a few things that have been going on. So one thing I have noticed is that she has at least issued a couple of orders that have not just been paperless orders, but that's not helping much. We have, I would say, right about here was where her second like questionable moment kind of came in, where we have a denial without prejudice of special counsel's motion to compel disclosure regarding advice of counsel defense. So if you all will remember, Mr. Trump likes to go to the media and say, well, I was relying on counsel. That is an affirmative defense. Sorry, that's my cat again. And if you want to plead an affirmative defense, you must plead that before we go to trial, or else you lose the right to use it. Now, that's the rules for everybody. Now, he claims, affirmative defenses don't necessarily include advice of counsel defense, and there was some question about that. Judge Chutkan had a similar issue going on here, but everything's been paused in the DC case. But for this one, Judge Cannon's just said, yeah, he doesn't have to plead any of it right now. So we've had some questionable things going on. Now, keep in mind, everybody, as we go through this discussion, Judge Cannon and Judge Chutkan, both of them are kind of new in their positions. Judge Cannon has already had a case reversed on this particular case. It was involving a warrant, and she had previously, when there had been a warrant for Mr. Trump's property in Mar-a-Lago, had decided to kind of make a set precedent and ask for like a special master to kind of oversee everything, which was way out of her allowances. Hello, Olga, good to see you. So she had overstepped her boundaries in that case, and the 11th Circuit had reversed her because of that. So if anyone will remember that situation. So she's been reversed already when it comes to Mr. Trump and making these kinds of issues. And she's still kind of, we're kind of struggling here. So we have anything in orange is Mr. Trump, anything in green is the government, and pink is the court, just to keep everyone up to date. So when we're dealing with classified documents, everybody, we have special statute that governs how we have to act, because we have to be pretty careful so that people don't say, well, hey, I'm just going to tell everybody what's in those documents unless you drop the charges. So we have to be careful. Yes, she did, Mary. She said Trump should be treated specially. And to some degree, I can see her perspective because we've never dealt with this situation before. But I don't necessarily think that just because we've never dealt with it, that he needs to be treated advantageously. I think we can be careful in how we treat a case without giving him extra bonuses, which really is what's going on. So, what are we covering tonight? Yeah, so we're kind of covering an update on the Florida case, everybody. So we have here a motion to compel discovery by Mr. Trump that was filed the 16th, and I've gone through that, and he's explaining, he's just kind of being unpleasant about that. We have a notice of filing here, a notice of filing, and then a paperless order on the 17th. I'm kind of walking you through to get you to where we are today, everybody. Here we've got receipt of Trump's notice of a SIPA challenge on or before January 18th. Here shall file a notice confirming non-ex parte nature. So what's happened? Let's talk about the SIPA situation. So because we have classified documents involved, right? Even though he doesn't have the classified documents in his possession, he's seen them. The other people have seen them. We don't know if there's been copies made. We just don't know. But these are important classified documents. What level of classification? They're all 3 levels. We just don't know. Could be top secret, could be middle secret, could be low level secret, but they're all secret documents. So we have a statute that was passed by Congress, all right, which, back when Congress passed stuff, we have an act called the Classified Information Procedures Act. And it sets out how we deal with criminal trials when we have confidential information or classified information as part of our evidence. Because there is a discovery period, there's all kinds of things that you go through during a normal criminal trial, and the defendant has a right to see the evidence against him. And so, of course, but we also have to be careful because we have top secret information that we don't want to be just tossing around willy-nilly. So we have multiple sections that are set out. First, again, just to remind you, we'll refer to this as SIPA. We've got section 1 here, defining classified information. We have the pretrial conference that was set up, which we have in all criminal procedures or proceedings. And then we get into section 3. Now, section 3 was something Judge Cannon really dragged her feet on. We had a protective order request. So Jack had said, hey, we've got some really specialized information. We kind of need to keep it protected. Judge Cannon waited a very long period of time until she actually put the protective order in place, but she did eventually put it in place. Next, we have discovery of classified information by defendants. So this is what's in controversy, everyone. We have proceedings, protocols that we have to follow in order for the defendant, that would be Trump, in order for him to have access to classified information. So the rules have to be followed here. We have to have, let me just read this section out because this is really what is at issue. The court, upon a sufficient showing, may authorize the United States to delete specified items of classified information from the documents to be made available to the defendant through discovery under the Federal Rules of Criminal Procedure, to substitute a summary of the information for such classified documents, or to substitute a statement admitting relevant facts that the classified information would tend to prove. So it's possible to give a summary or, something other than the actual classified document itself. It's possible. The court may permit the United States to make a request for any such authorization in the form of a written statement to be inspected by the court alone. The court alone is really important here. The court alone means ex parte. So only the court can see this, only the court. That's very important. Remember that. If the court enters an order granting relief following such an ex parte showing, meaning only the court, the entire text of the statement of the United States shall be sealed and preserved in the records of the court to be made available to the appellate court in the event of an appeal, which, is likely. So this whole section is saying here, as long as we have a sufficient showing, there can be an authorization of certain items being redacted or carefully protected from giving to the defendant, okay? So, and that's all because of how this statute that was passed by Congress was written. So this is important. Let's remember that as we go through some of the issues that we're having here. Next, we have notice of defendant's intention to disclose classified information. So this section sets out what are we going to do if the defendant starts to say, well, I'm going to disclose classified information that's involved in this trial because I don't care about anybody else but myself. And it's going to be a benefit to me to disclose it, and I shall now disclose the information. Well, we've got to go here. We've got to go to Section 5 then and make sure that that's okay. So if we've got notice by defendant and they follow the rules, then, that information can be disclosed, and that's okay. Also, we do have a failure to comply piece as well. So we also have procedure for cases involving classified information down here. So we have motions for hearings. So when you hear about that SIPA hearing, it's because it's set out by the code, and then they go into multiple pieces of that. But what I really wanted to make sure I highlighted here was this discovery of classified information. Because Mr. Trump, it's a very interesting situation because he's filed a motion to compel discovery. So he's saying that Jack needs to give him a whole bunch more discovery that Jack allegedly has, which Jack says he doesn't, but it has to give him a whole bunch more discovery here. And the issue, one of the issues is first, he doesn't have the information. The other issue is that, it's classified information. So if there's classified information, we have to follow the procedures. So that's a big piece of it. Now let's take a look in here. We have a non-ex parte filing by Mr. Trump, and then we have a response to the motion by the U.S. here. And then we have a motion to intervene by some news people, and then we have a response in support of the motion to compel discovery. So again, we have this compelling discovery similar to the DC case. We have a response in opposition by Mr. Trump for the intervention and unsealing of defendant's motion to compel. And then we have the government coming in a supplemental response to the standing discovery order. So this is that order or the motion where the U.S. came in and said, look, we've given you everything that we have. We have a notice of an attorney appearance here. I'm just flying through this to get us up to date, everyone. So next we have a notice of filing by the U.S. also here. And then we have a paperless minute order here. Entry for sealed ex parte proceeding held before Judge Cannon on January 31st. So there was an ex parte hearing between the government and Judge Cannon. The court heard argument from special counsel on its SIPA Section 4 motions. So that was the section we just talked about. So she heard Jack argue why he felt like some information needed to be redacted or taken care of. Total time in court was 3 hours. So we have a paperless minute entry. So basically it's just kind of like noted we had a hearing. That's it. We don't have an order out of that hearing. Next, we have a response on February 2nd. All right, so now we're going to get into more information on what's going on right now. We have February 2nd, a response in opposition by the U.S. as to Trump's motion to compel discovery. So again, they're going through and explaining, we've already given you everything, and what you're asking for, we don't have. This was where Trump was saying anyone that had had any contact with Biden's relatives, or could have possibly have contacted Biden or his relatives, had to give over information on whatever. It was just one of those situations where it was too broad. What he wanted was too broad. You got to be more specific. Next, we have an unsealed motion for permission to file sealed and redacted documents by the U.S. So we're going to start to get into this issue now where the government is saying we're trying to redact and protect the nation's secrets here. And, we'd like to do that according to the law. So let's see what happens. We have another notice of filing of classified opposition by U.S. here. So we've got some classified documents that the government's trying to redact. Now we have a scheduling order on the SIPA 4 hearings here. See attached document again. So we've got that. And then we've got a response to the motion by the U.S. Motion to intervene and unseal defendant's motion to compel discovery was filed. Then we have another order. So you have an order granting in part defendant's motion for temporary leave to file redacted motions and denying as moot Press Coalition's motion to intervene and unseal, signed by the judge. So one thing to notice, everybody, is this is an actual order. This is not a paperless order. Most of her orders are paperless, and this is an actual order. So we'll take a look at this. Kids in school wrote letters to the president. Yes, right, exactly. All right, so we'll take a look at this order that she did actually file. Since they're so rare, we'll take a peek at it. We have a speedy trial report, which is just part of these proceedings that has to be filed by the government. Then we have a motion for adjournment of certain pretrial motion deadlines by Mr. Trump. So he's asking for certain pretrial motions, the deadlines to not be going forward. Then we have another order. Again, everybody, not paperless. It's shocking. We've got two now. Two orders that aren't paperless. Granting in part special counsel's sealed motion for permission to file sealed and redacted documents. So she's only granting in part Jack's request for sealed documents. All right, everybody? So only a piece of what he's requesting. Now I'll take you through his motion explaining what he's asking to be redacted here in a couple of minutes, because it's pretty significant. It's pretty significant. So again, this is our overview before I dive in here. So we've got another motion by the government for leave to file an exhibit ex parte and under seal. We've got a filing of a SIPA Section 4 supplement, a response to the standing order discovery by the government, opposition again filed. Now we're back to our paperless order, and this is where we start getting a little bit confused, everybody. So paperless order granting the special counsel's motion for leave to file exhibit ex parte and under seal. So that was granted. The motion is granted insofar as it seeks leave to file the subject exhibit under seal for the reasons stated in the motion. The motion is also temporarily granted as to the ex parte nature of the request, pending the court's in-camera review of the exhibit. On or before February 9th, the special counsel shall submit the subject document to the court under seal and ex parte. So we're allowing it, but we're needing Jack to file some extra stuff. We have a motion for reconsideration, everybody. This is the key. This is the turning point in this case. So Jack has asked multiple times to have things redacted, to have things to be filed under seal. She granted in part and did not grant in part. And now he's saying, I'm going to need you to reconsider your last order. So the reason why anyone in the government would file a motion for a reconsideration, this is a step before we appeal it. So this is basically saying to Judge Cannon, hey, I'm going to give you a chance to kind of clean up a messy order. And then if you don't, I'm going to appeal. So when we have this question now of will Jack appeal Judge Cannon and request it to go to the 11th Circuit, this is that moment. We will see what happens in her response to this. And I will take you through this motion. So her response just within the next couple of days, again, we only have paperless orders again, back to the paperless order. On or before February 23rd, defendant shall file a response to the special counsel's motion for reconsideration. So now she's asking the defendant to put a brief in on how he feels about Jack asking for reconsideration. All right. So she's saying that needs to be due February 23rd. And the order impacts defendant's forthcoming reply in support of motions to compel. So, of course, Trump is asking for access to this information, which he doesn't have a right to. And Jack has explained that. And she's saying, well, I want a brief. And so she's reset deadlines here. The motion for reconsideration has been moved. Now we've got a notice of resealing. So we do have Walta Nata coming in as well. Notice for the regarding the sealing. Paperless order approving the proposal stated in the notice. And then another paperless order as well. redesignating ex parte sealed filings. So she has resealed. So she said, I'm going to grant in part and not grant in part your request. Jack said, I'm going to need you to reconsider. And so she said, well, I'm going to go ahead then and keep everything sealed until everybody's briefed it and we've had a hearing. So she's wanting to have a whole bunch of information supplied to her before she decides to make her decision. And you'll see why this is. She's really asking for a lot, everybody. She's asking for a lot of extra work, a lot of extra briefing and hearings on something that should be relatively simple if you read through the SIPA statute here, which is one of the things that is just blowing my mind. All right, everybody. So let's take a peek at the government's motion for reconsideration and the stay. So how old is she? I'm not sure. That's a good question. So Jack filed, everybody. Again, this is very legally very exciting. This is the tea. If there was tea in the legal field, that would be this. So here's the tea, everybody. Oh my gosh, she's 13. Well, I don't know. This is pretty big. This is a pretty big deal, everybody, because Cannon has really backed herself into a corner because she has already held, I'm going to allow some of this to come out. Now she has put that on hold after he filed this reconsideration, but she has still not decided. It's only on hold. So she could make this information public. So as we go through this, let's take a look at this information he's trying to protect and figure out whether or not we're going to have some troubles here. All right, government's motion for reconsideration and a stay. So in two recent orders, 283 and 286, the court has denied the government's request to seal or redact certain material that was provided to the defendants in discovery pursuant to a protective order. All right, remember that section of the code regarding protective orders, and then attached either to the defendant's motion to compel discovery or government's response thereto. That discovery material, if publicly docketed in unredacted form, as the court has ordered, but has paused it temporarily, would disclose the identities of numerous potential witnesses along with the substance of the statements they made to the FBI or grand jury, exposing them to significant and immediate risks or threats, intimidation and harassment, as has already happened to witnesses, law enforcement agents, judicial officers, and Department of Justice employees whose identities have been disclosed in cases in which defendant Trump is involved. So this is pretty major, everybody. He's wanting to keep their names and information confidential as a way to protect them, hence why we had the protective order, which was allowable under the statute. All right, I'll keep bringing this statute back, everybody, because you don't have to rely on me. This is the statute itself. We have protective orders that are required, and then we have a discovery of classified information here. To reach this conclusion, the court reasoned first that because the defendants chose to attach these discovery materials to court filings, the government bore the burden to demonstrate that the sealing or redaction is necessitated by a compelling government interest, which is the most strict type of level and is narrowly tailored to serve that interest. This is the standard we use on First Amendment questions or any kind of equal protection issues. So that's a really huge, high standard. All right, the court then found that the government's justifications, including protecting witness safety, grand jury secrecy, and the integrity of the trial, failed to satisfy this heavy burden. This conclusion was wrong in two respects and should be reconsidered. First, the 11th Circuit, which is where he would appeal this, has held that the compelling interest standard applied by the court does not apply to documents filed in connection with motions to compel discovery, which instead may be sealed or redacted simply upon a showing of good cause. So here's our issue. She is asking for this compelling interest, which is a huge burden, And the actual legal interest or the legal level is good cause. So that's pretty significant. All right, that's huge. She's using the wrong law, and it's a big difference. It's not like middle of the road either, like, oh, a little bit one way or the other. Good cause versus compelling interest is huge. The government has readily satisfied that standard here under the Federal Rules of Criminal Procedure, number 16. I did not get the notice today. Oh, that's okay. Oh, that's all right. We're just diving in, just getting started. And because the court applied the wrong legal standard, which is explained below, the government did not discuss in its prior filing reconsideration is warranted to correct clear error. And then we're citing case law. So let's talk about that for just a minute. We've got an error, and the reason I want to bring that up is because, let's see. Because when we are looking for any kind of issue involving a recusal, all right, so we've got some standards that we look for when a judge has to be recused. We have a discretionary recusal. A judge may recuse themselves from a proceeding whenever the judge deems it appropriate. Mandatory recusal. A judge shall recuse themselves under circumstances that will require disqualification of a federal judge regarding the code of conduct, except that the required recusal may be set aside under different conditions. A request for a recusal. Any party may request that the judge at any time following the judge designation and before filing of a decision be recused under paragraph A or B of this section or both by filing with the judge promptly upon the discovery of the alleged facts, an affidavit setting forth in detail the matters alleged to constitute grounds for recusal. So we've got if there's some kind of conflict of interest issue, and then ruling on request. If the judge finds that the request of recusal has been filed with due diligence and that the material filed in support of the request established the recusal either is appropriate under paragraph A or is required under paragraph B of this section, the judge shall recuse themselves from the proceeding. If the judge denies a request for recusal, the judge shall issue a ruling on the record. So we're already starting to talk about what it is that we're going to need in order to have a recusal, everybody. One of the grounds for recusal is when the wrong kind of law is being used. All right, so keep that in mind as we keep going through this. So here's number one. We've got the wrong standard of law used. Now, this isn't a make or break situation. Judges use the wrong kind of law, true, but that it just means they have to correct it. If you use the wrong law, you have to fix it. Next, second, in addition to ensuring that the correct legal standard is applied, reconsideration is warranted to prevent manifest injustice. Now, the reason why we're using terminology like this, everybody, in my opinion, hold on here. All right, in the 11th Circuit, everyone, there is, when a judge is asked to recuse themselves, they have to consider it themselves. But if they decide not to recuse themselves, it's possible for the Court of Appeals, for the appellate judges, to push the judge out, to ask the judge to leave the case. All right. Now, I bring this up because it's very rare and we have to have an extraordinary measure involved. So something I really want to remember, though, again, as we go along, is whether the reassignment of a different judge to the case would help preserve the appearance of justice. So we have this issue here of preventing manifest injustice. And so we're going to want to make sure that if a recusal does not happen, that a removal could possibly happen. Is everyone following me on that? The court orders require the public identification of more than 24 people who participated in the investigation. Some may never testify at trial and therefore would otherwise be able to retain their anonymity and privacy absent the court's orders. Others are expected to provide important trial testimony and will likely be subject to threats, intimidation, and harassment if their identities are revealed. A likelihood that is concrete and palpable and possible in this case, as the record reveals and other judges have recognized. The First Amendment does not require the disclosure of the witnesses' identities, particularly where, as here, their identities have no bearing on the resolution of the motion to compel. So again, we're talking about that motion to compel discovery. The government therefore respectfully requests that the court reconsider its recent orders to permit the sealing or redaction of exhibits that identify any prospective government witness, constitute Jenks Act's material for the same, or contain sensitive information described below. The government further requests that the court stay the orders directing the parties to file newly redacted submissions on or before February 9th. Pending the resolution of this motion to reconsider, the government has conferred with defense counsel and they oppose. So let's look at footnote number 1 here. They state, this is the defendants object to the special counsel's effort to reconsider after full briefing whether there is a valid basis under the law to seal the motions to compel briefing. The defendants reserve the right to respond to any new authority cited by the special counsel's office within a reasonable period of time. We do not oppose an extension of time to submit proposed unredacted submissions to permit the court to consider the expected motion for reconsideration. So this is interesting because this is the defendant's position, and this is what Judge Cannon has done. She has said, I want you guys to put briefs in so that I can have some extra time to take a look at this motion for reconsideration. So defendants have said, yes, we want the judge to have more time, and if she wants to do briefings, great. And then voila, she's now asking for briefing. All right, so that's a little bit suspicious. Procedural history. So on June 16th, the government sought a protective order. So June 16th, everybody, to govern the handling of unclassified discovery in this case because the discovery materials include sensitive and confidential information, including the following: personal identifiable information covered by Rule 49.1 of the Federal Rules of Criminal Procedure, information that reveals sensitive but unclassified investigative techniques, non-public information relating to potential witnesses and other third parties, including grand jury transcripts. That's kind of important. The transcripts are a big bit. So, and exhibits and recordings of witness interviews. That's also important as well. Financial information of third parties, third-party location information. That's important. And personal information contained on electronic devices and accounts, so the phone information. The materials also include information pertaining to ongoing investigations, the disclosure of which could compromise those investigations and identify uncharged individuals. On June 19th, the court entered the protective order over unclassified discovery. It provided that defendants shall not disclose discovery material in any public filing or in open court without notice to or agreement from the United States or prior approval from the court. From that time until now, no witness names have been mentioned on the public docket. Indeed, the court admonished all parties to anonymize references to witnesses at the Garcia hearings, both in its order setting the hearings and during the hearing itself. References during the hearing to identify potential witnesses are to be made in accordance with the witness designations as stated in the motions. The individuals that have been referenced in these papers have been referred to as follows: Trump Employee 3, Witness 1, and Witness 2, if everybody remembers our Garcia hearings. So the Garcia hearing, everybody, just so that we recall that moment. Garcia hearings are held when there could be a potential conflict of interest between the attorneys representing the defendants and the attorneys also representing witnesses in front of grand juries. It was deemed that the conflict was fine. On January 16th of 2024, the defendants filed their motion to compel discovery, along with a motion for temporary leave to file redacted brief. In the latter motion, the defendants made no attempt to show why an exception to the presumptive confidentiality of the protective order was warranted, and instead merely submitted that no compelling interest in sealing the motions exists. 2 days later, consistent with the protective order, the government responded to the motion for temporary leave, opposing it to the limited extent that the motion to compel or its exhibits identify any prospective government witness. constitutes Jenks Act's material for the same or contains certain additional discrete sensitive material. On February 2nd of 2024, the government filed a motion for permission to file sealed and redacted documents in connection with its unclassified response to opposition to defendant's motion to compel discovery. On February 6th, so just a couple of days ago, the court issued an order granting in part the defendant's motion for temporary leave to file redacted brief. The court granted the defendant's request for unsealing as to the names. This is important here, the names of potential government witnesses and their statements based on its conclusion that the government failed to carry the heavy burden of showing that sealing was necessitated by a compelling governmental interest and is narrowly tailored to serve that interest. Again, that's the standard the government is saying is the wrong standard that the judge uses here. On February 7th, the court issued an order ruling the government's motion for permission to file sealed and redacted documents, directing the government to comply with the redaction instructions in the court's earlier order for the reasons set forth therein. Applicable law. A motion for reconsideration. So again, this is a pretty big moment to ask a judge to reconsider. Although the federal rules of criminal procedure do not specifically authorize motions for reconsideration, both the Supreme Court and the 11th Circuit, which is the appellate court, so like her bosses basically, oh dear, have permitted parties to file such motions in criminal cases, citing case law, lots of case law here. In the Grobman case, he has been citing quite a bit. As in civil cases, there are three major grounds which justify reconsideration. 1, an intervening change in controlling law. 2, the availability of new evidence. And 3, the need to correct clear error or prevent manifest injustice. Yikes! So I think number 3 is the one. Reconsideration is an extraordinary remedy that should be employed sparingly. She's getting schooled. Yes. Oh my gosh. Okay. B, public access to discovery material produced under the protective order. So again, remembering that protective order that was set out, again, which is allowable and needed in these kinds of cases. Both the First Amendment and the common law grant, hold on. For both the First Amendment and the common law, hold on everybody. The common law, does that mean only the common law or only the case law from back in the old days? Or does this mean all case law? I'm going to have to ask legal dad about that. All right. Both the First Amendment and the common law grant the press and the public a qualified right of access to criminal trial proceedings and certain judicial records. Now, that's a quote from 1980. But neither the First Amendment nor the common law grants the press or the public a right to access discovery materials. The First Amendment's right to access attaches only when the tests of experience and logic have been met, citing case law here, which requires court to consider 1, whether the place and process have historically been open to the press and general public, and 2, whether public access plays a significant positive role in the functioning of the particular process in question. But as the 11th Circuit has ruled, discovery fails to satisfy either test. And so this is really important. Historically, discovery materials were not available to the public or press, and discovery has long been neither a public process nor typically a matter of public record, but rather essentially a private process, and the sole purpose of which is to assist trial preparation. So I think that's a key piece as well, everybody. Although not good for me because I can't see it if they don't allow it. But on the other hand, that's what's important. And far from playing a significant positive role in discovery's functioning, the prospect of all discovery being presumptively subject to the right of access would have a deleterious effect, as it would likely lead to an increased resistance to discovery requests. As citing the Chicago Tribune case, if it were otherwise and discovery If it were otherwise, and discovery information and discovery orders were readily available to the public and the press, the consequences to the smooth functioning of the discovery process would be severe. Because discovery material fails to, and again, this is from the 11th Circuit, satisfy either prong of the experience and logic test, the First Amendment right to access does not attach. So what they're saying here, everyone, is you have no First Amendment right to discovery information because the test is not satisfied in court, all right? So we've got also the Nickens case, the Gonzalez case, and then Chicago Tribune again here, where a protective order governing discovery materials is entered on a showing of good cause and does not restrict the dissemination of the information if gained from other sources, it does not offend the First Amendment. The common law right, common law right, does that mean case law or does that mean historical? I don't know. Oh no, legal dad, where are you? I'll have to ask legal dad about that one again. Goodness. The common law right of access is also inapplicable. Although it concludes the right to inspect and copy public records and documents, it does not attach to discovery materials or, crucially, to material filed with discovery motions. Indeed, the 11th Circuit has refused to treat all documents filed with the court as judicial records, instead adopting a more refined approach. That accounts both for the tradition favoring access as well as the unique function discovery serves in modern proceedings. Under that approach, material filed with discovery motions is not subject to the common law right of access, whereas discovery material filed in connection with pretrial motions that require judicial resolution of the merits is subject to the common law right. This means that the documents filed in connection with the motions to compel discovery are not subject to the common law right of access. Indeed, materials submitted to a court for its consideration of a discovery motion are actually one step further removed in the public concern from the trial process than the discovery materials themselves, and then we're citing case law here. In sum, discovery materials, including materials attached to a discovery motion, such as a motion to compel, do not fall within the scope of either the First Amendment or the common law right of access. So there is no right of access for discovery material, everybody, according to Jack's argument here. All right, so here's our argument. I am going to skip kind of through this a little bit. This is a pretty long motion, but we'll hit the highlights, everybody. Here's the argument. So reconsideration is warranted to correct clear error and prevent manifest injustice. As explained below, the court applied the wrong legal standard and issued orders that in practice will expose witnesses and others to intolerable and needless risks. Before addressing those issues, however, the government responds to the defendant's procedural objection. Although the government is cognizant of the fact that motions for reconsideration should not be used to present new evidence or argument, reconsideration is appropriate here given the context in which this discovery dispute has arisen. So, again, I think this whole thing is just ridiculous. The defendants here were not legally entitled to a list of the government's witnesses or to their statements or grand jury transcripts prior to trial under Federal Rule of Criminal Procedure. So, yeah, we have rules for that. The rules reflect a key purpose of the Jenks Act, which is to protect government files from unwarranted disclosure. The government has nevertheless produced those materials and more far in advance of trial in minimally redacted form, but only because the materials were subject to a protective order that allows the defendant to prepare for trial while limiting the risks of unwarranted disclosure in part by stating, quote, defendant shall not disclose discovery material in any public filing or in open court without notice to an agreement from the United States or prior approval from the court. So the reason they were so open with all of the discovery was because there was a protective order in place. Shouldn't she know that? She really should. She should know that. That is precisely why no discovery was provided until the court entered its protective order. And while the protective order permits the defendants to seek court approval when the government's agreement has been withheld, that procedure presupposes that the burden is on the defendants to justify the basis for publicly disclosing presumptively confidential discovery material, including by justifying the basis for revealing the identities of witnesses and the substance of their expected testimony. So the defendant has the burden to show why it's so important that he's able to share the names and information about the witnesses here. A contrary rule would turn the principles of discovery on their head and imperil the ability of prosecutors to provide early and thorough discovery, as the government has done here. The defendants may not evade the strictures of the protective order by the simple expedient of filing protected discovery materials with the court and then claiming that their unilateral decision converts the discovery materials into judicial records that are presumptively open to the public unless the government can show otherwise. So I'm going to pause here. That is one thing that I have noticed from the very beginning that has been a bit frustrating. And I think it's coming out in this motion here, is that it seems like even originally, if we go back to the DC filings, everyone, there were some things attached as exhibits onto multiple motions that Mr. Trump had filed where it was questionable. Like Judge Chutkan had said, I'm not going to allow this kind of material to be shown publicly. But yet it was attached onto a motion, and because of that became part of the judicial record and therefore became public. So if you just basically attach something onto one of your motions, just any motion, then it no longer becomes discovery that has to be protective. And what he's saying is that it's part of the record now. And so it can be made public just by filing a motion regarding it. And that has been something that has definitely been his style that I have noticed, which is one of the reasons why we've had access to so much of the information. One of the things that I found fascinating with Judge Engoron was that he was putting his emails directly into the docket. He was like, look, it's going to be in the docket. This is all going to be public. This is all going to be open to anybody that wants to take a look at it. Because rather do that than have someone try to file it attached to some other random motion. Yes. So not all evidence, Jennifer, is public. Not all evidence before trial. Now, during trial, all of this evidence comes out. All of this information comes out during trial, all right? Because trials are open and public. But before the trial itself happens, no. I mean, a lot of that has to be kept because we don't want to taint the jury pool, all right? So we haven't picked our jury pool yet. We don't know who's going to be called in. And so if evidence comes out because it was attached to a motion and the potential jurors see that evidence, technically the judge may want to keep that evidence out of the trial. But now the jury pool's been tainted because they've already seen evidence that they shouldn't have seen because it's not been ruled on yet. Wait till you see the response. Yikes, I'm worried. I'm worried. No, I'm concerned. All right. So that's where we're going here with this. So we've got the Chicago Tribune case as well. The free flow of information will cease if parties resist entering umbrella orders because they fear such orders could be subject to document by document poor judgment attacks here. So otherwise it would render protective agreements largely meaningless, since a defendant could merely append any document subject to such an agreement that he wishes to publicize, no matter how irrelevant, to any dispositive motion, and then bring a motion to unseal, which obviously would defeat the purpose of such protective orders. So this is exactly what I was talking about. The first The first thing that I noticed was an entire transcript of an entire hearing that he attached to a motion. Rather than just pulling out a few pieces that he needed, he attached the entire transcript of this hearing that was not made open to the public, but he attached it to a motion, so it became public record. All right, so the government relied upon the full protections of the court's protective order in drafting and submitting its filings and did not understand that it would be required to provide specific additional evidence to support line-by-line redactions of materials that the court had already found good cause to seal. Citing the Seattle Times case, heightened First Amendment scrutiny of each request for a protective order would necessitate burdensome evidentiary findings and could lead to time-consuming interlocutory appeals, as this case illustrates. So each time she disagreed with a redaction, he could appeal it. And you can see, so if he has 100 documents with 100 redactions in it, one by one, she's like, nope, this can be okay. And so he'd have to appeal it. The second redaction, she's like, it's fine. He would have to appeal it over and over and over again for 100 different redactions every single time. So you can see how that would be a problem. In light of this context, even if the court finds the government's prior filings did not adequately address the issues before the court, it should exercise its discretion to consider the arguments and evidence below before resolving the request for continued sealing. The witnesses should not be placed in risk simply because the government relied on its good faith understanding of the protective order. And again, the good faith understanding is that standard that he's saying is appropriate as opposed to the clear and convincing. That's just crazy. I know. That would take forever. It certainly would. Clear and convincing was not it. It was the First Amendment. So compelling interest. All right. A, reconsideration is warranted to correct clear error. Number 1, the government was required to show good cause, not a compelling interest in narrow tailoring. In requiring unsealing, the court applied the wrong legal standard. Like the district court in the Chicago case, which is what we were talking about earlier, the court determined that the government's showing was too general and conclusory to carry the government's burden of showing that the closure of the records filed with this court is necessitated by a compelling interest and that the closure is narrowly tailored to that compelling interest. But because the materials that the government sought to seal or redact were discovery materials attached to a discovery filing, the requirement that the government meet a compelling interest standard predicated on a constitutional right of access was error. So he's saying, you know what, that's incorrect. You have an error here of law. What's your view on how Ms. Cannon could make this error? I think she, that's interesting that you asked that because, we have had, so this is the opinion that the 11th Circuit wrote where they reversed her previous case. So in her previous decision, she had added this extra person to kind of oversee what's going on. She has this ideology that Mr. Trump needs a special consideration, right? And, there is some truth in that. He is a former president, so there's some truth in that. But she's taking it so far. And I think what she's doing is she's just pushing as far as she can go because she knows this is the first time that this kind of a case has been in court before with a former president. She doesn't have any experience, to my knowledge, on classified documents. So this whole SIPA statute that she's working under, she is not familiar with. And there's a pretty big difference between running the kinds of trials that you do day in and day out in a Florida district court and even at a federal level, your drug cases and so on. There's a big difference between those kinds of cases and a case involving confidential information, classified documents. And I think she has underestimated the amount of work that it takes to run a classified documents case. That's my thought. I think she just did not realize. She probably thought, oh, well, we'll just add a couple of extra bits and bobs and it'll be fine. As opposed to really understanding the true impact, it may just not seem that important to her. for some reason or another, or she's too busy to give it the importance that she wants, or she is somehow thinking that, well, whatever I'm doing is in the best interest of this former president, which is definitely the wrong ideology to have in this situation. Judiciary needs better rules on who's assigned to which cases instead of on call. Yeah, that's a good question, VC. I mean, what do? We try to make it as random as possible, but then this kind of thing happens. But then everybody, the thing is, when judges screw up, the Court of Appeals knocks them back down. So if she is screwing up here, and so Jack has filed this motion for reconsideration because he's basically, this is him filing, if you were in a work situation and you need to file a complaint, this is basically his complaint. He's getting it on the record. You screwed up, and if you don't fix it, I'm going to go to your boss. That's what this motion for reconsideration is. Now, she may be like, I was just trying to do the best thing that I thought I could do in the situation. And he's like, sure, that's fine. But I'm telling you what the law is, and you need to be in compliance with the law. That's your job. Yeah. So, yeah. And I think she's being she's definitely, I'm not going to go as far as to say that she's biased towards Mr. Trump. I cannot bring myself to see that, knowing that she is a judge. She has earned the position that she has. So I'm not ready to go that she's fully biased for some political reason. But I am willing to say her inexperience and perhaps the star quality of having a former president in her courtroom, maybe those elements have added to her inability to really focus on what she needs to focus on here. Need a hostage negotiator for a chop shop. I know. I know. Well, and it seems like, I use this term bias in a legal sense. Like there is a high standard that you have to meet in order to be biased at the level of recusal. So normally when we think of bias, when we think, oh, well, that person's biased. If we're talking just normal vernacular, oh, absolutely, she's biased. Absolutely, in just normal everyday vernacular. But the legal standard needed for being biased as a judge in order for recusal is much different than just an English word of biased. So does she have leanings towards Mr. Trump? Yes. Does it rise to the level of legal bias under needing to be recused as a judge? That I don't think we've hit yet. So that's kind of how I would put that. So when I'm saying I don't think she's biased, I'm saying I don't think she's legally biased to a level of recusal. I mean, clearly she has a soft spot for Mr. Trump, but that's allowable, and judges can have those soft spots. She seemed bedazzled by his vision. Yeah, I don't know about that, but she's very qualified and pushed through. True. And, Mary, the thing is that it just happens. It just happens. I wish it wasn't something that happened, but we can go all the way back to Marbury versus Madison. And a lot of those judges were not necessarily the best judges to put in. A lot of the judges appointed right after the Civil War were like barely judges themselves. I mean, it's not unheard of. It's kind of one of those, issues that we have with our system. And we do the best we can, but we don't exactly have a ton of judges to pick from either. We got to kind of fill the seats. Admire your dedication to your ethics. We can say it, though. She seems biased. Go for it, Daisy. Go for it. Say the words I cannot say. Oh, my goodness. That's so funny. All right. Let's dive back in, everybody. Oh, my gosh. So, yeah, just to kind of clear that up a little bit. All right, number 2, the government we're going to skip through here. The government established good cause. So again, we've got this good cause standard versus the compelling interest. Applying the correct standard of good cause would have resulted in a different outcome. This is key. That's one of the most important things on an appeal. Would a different standard have made a difference? If so, if not, then, it's a harmless error. But if it would have made a significant difference, now we've got an appealable issue. Again, In this context, the good cause standard is equivalent to a standard for issuing a protective order. Again, a protective order over the discovery materials. Here, under Rule 16d1, good cause can be based on such considerations as the safety of witnesses and others, a particular danger of perjury or witness intimidation. So I would say we've got witness intimidation issues, the protection of information vital to the national security, and the protection of business enterprises from economic reprisals. So that's the standard for showing good cause. So I would definitely say he's got some checks here. We've definitely got safety. We've definitely got witness intimidation. I don't know if we've got national security questions, but he's definitely ticked several of these boxes. In granting the protective order, the court necessarily found good cause, and it has reiterated the concerns underlying the finding when taking care to anonymize witness names from public during the Garcia hearings. So that's the other thing too, is that they already met the burden because they have a protective order. So the protective order's already met the burden. Not only that, but she reiterated it during Garcia. So she even herself said this is important. Is getting into what exactly my thoughts on that. Yeah. None of these considerations animating the protective order have dissipated since it was granted. So if there were grounds, everybody, for the protective order, if the grounds were proper for the protective order, let's just put it this way, then there are proper grounds for the redactions that he's asking for. Grounds for redactions. Because it's the same standard is what he's saying here, okay? So, in opposing the unsealing request by the defendant, the government objected to the unsealing or public dissemination of any information in the motion's brief or its exhibits that A, reveals the identity of any potential government witness, B, reveals personal identifying information for a potential government witness, or C, constitutes Jencks Act's material for any potential government witness. In doing so, the government emphasized three main concerns: the need to protect the witnesses from harassment and intimidation, the need to avoid infecting the testimony of other witnesses or unnecessarily influencing the jury pool. I don't know if we need that to use that word, but it's a direct quote. So we don't want to influence the jury pool, everybody. And 3, the need to protect personal privacy, including by avoiding disclosure of uncharged conduct as to one or more individuals. All right, those legitimate concerns are paradigmatic ways of establishing good cause, and the government's interest in continued confidentiality greatly outweighs the disclosure interests of the public or the defendants, which is an excellent point. For example, protecting the participants in a trial is an integral part of protecting the integrity of the trial itself. And he's citing a ton of case law here. Ooh, this one looks good. Unmasking those who are cooperating with the government's investigation or who have otherwise provided information to the government could deter further cooperation from the investigation by subjecting those individuals to witness tampering, harassment, and retaliation. I mean, of course, right? If the government can't protect these witnesses who are going to testify, who's going to ever testify for the government? Who's going to do that? I mean, we're in kind of this mafioso situation where they're like, you can't protect me from the defendant, so I'm not going to say anything. That's what the government's saying here. Like, we promised them that we would keep it protected. And if we can't protect them, it will affect not just this case, but all of our cases in the criminal justice system, because the government will be seen as not being able to protect their witnesses. That's what doesn't make sense. They're all silent. Well, yeah, private planes. Oh, okay. Yeah, I mean, that's a problem. Yeah. Exactly. Mm-hmm. Leaked it to people who didn't need to know. Yeah, I mean, that's the issue, everybody. Can the government protect their witnesses? And if they can't protect their witnesses, then it will be complete anarchy. Dun, dun, dun. Anarchy. Anyone for either party will be intimidated into silence. Absolutely. Who was the protective order for? The protective order was for the witnesses and for the evidence to be protected before trial. Now, again, this is all pre-trial stuff. Once we're in trial, of course, we're going to see who the witnesses are. Of course, we're going to hear the evidence. We're going to hear the testimony. All of that will be made public. But before trial, there has to be some kind of protection put in place so we don't don't know who all the witnesses are, don't know all the evidence, don't know the testimony that they're going to give, because it could have an adverse effect on the trial itself, and it could actually prohibit, or it can interfere with due process itself. All right, these risks are far from speculative in this case. As early as August of 2022, Magistrate Judge Reinhart noted that the dangerous atmosphere for witnesses in this case, when deciding to maintain under seal the bulk of the Mar-a-Lago search warrant affidavit, finding that after the public release of any unredacted copy of the search warrant inventory, FBI agents involved in this investigation were threatened and harassed. What? Why would you not protect them? Well, I mean, because that's a good question, Olga. Let's take a minute and think about that. Why would Trump want to have the names of the government witnesses made public and what they were going to testify to? What would be the benefit of doing that? What's the benefit of Trump having the public names released? Wants to put the seeds to discredit and get the witness to not testify. Absolutely. Revenge. Absolutely. Absolutely. So the key with any witnesses, everybody, that's testifying is that, so we can have the supporters, right? So you can have the base go after them. Right. Is the intimidation element, right? Also is to discredit them, because that's what we do on cross-examination. Anytime we have a witness in front of a jury, it's up to the jury to determine whether or not they believe the witness. So if there's a big, huge media storm going around about how much this particular person's not trustworthy, and that gets to the potential jury pool, they may already decide before they even go into the courtroom whether or not a particular witness is credible, and that will totally destroy the case. As well as intimidation. Yep, exactly. Threatening them so that they don't want to testify. Exactly. To know what they'll say and planning for questions. That's a great point too, Jennifer, is that if the defense already has that information, all of this information is available to the defendants. They know who the witnesses are going to be. They know the testimony. They've got the evidence. All of that stuff is under the Jenks Act as well as Brady. All of that evidence, none of that's secret from the defendants. It's just not made public. And so the defendants are trying to make that information public. And so you have to wonder, what's the motivation? What's the rationale for it? Should be your priority to protect the witnesses. It really should be. Typically, Olga, that's why another reason why it's a bit suspicious here, why she's fighting this so hard. Like, this just wasn't even a question for Judge Chutkan. He'll use this for campaigning, probably. Place her as, I'm not sure about that. Plus, he wants to go after the ones that had his NDAs to sue. Ooh, that's a really good point, Navy vet. Who had NDAs with him? Yeah, that's an excellent point. That's a very excellent point as well. So if you're scared, if your name gets leaked out to the media and you've got, the extremists coming after you, I'm not going to say everybody in that group is bad. I'm just not going to say that. But there are extremists that go too far and they go after, the witnesses. The witnesses aren't going to want to testify, or they're going to suddenly forget what they need to testify about. So there's a lot of issues that can go on. It'll be like Ruby and her daughter. Absolutely, Mimi. That's exactly right. That's exactly right. Their lives were destroyed, and so can these witnesses. So a lot of issues going on. The NDAs are invalid to some degree, but who knows that? I mean, it's all about whether or not you understand that your own NDA was invalid. If you've got a question about it, you may still fear being sued. All right, so we've got the prior judge, the magistrate judge from 2022, already putting out protective orders. We already have that standard, that basic bare minimum level standard met. Magistrate Judge Reinhardt himself has been subject to numerous threats as a direct result of his involvement in this case. And again, I mean, that shows you where we're at when people are going, the extremists are attacking judicial officers, right? There is clear and demonstrable pattern in which numerous people have had their lives turned upside down after being publicly identified as a participant in a proceeding involving defendant Trump. Again, that's an excellent example of Ruby and her daughter. The presiding district judge in the election case received racist death threat. The special counsel and his staff have been subject to threats and harassment. The chambers of the justice presiding over the civil fraud case in New York have been inundated with hundreds of harassing and threatening phone calls, voicemails, emails, letters, and packages. And potential witnesses against him are routinely subject to the sort of threats that pose a significant and imminent threat to individuals' willingness to participate fully and candidly in the process, to the content of their testimony and evidence, and to the trial's essential truth-finding function. So we basically, this is the same as everybody. It really does remind me a lot of the mafioso, all right? Where instead of like, we're going to go after your family, what he has, instead of it's his own, group, what he has is this base of people. So we could, the extremists, so we could almost look and see, like if you were to look at the mafia structure where you have the people out in the street, right, doing the street corner work, that's the extremists in this MAGA situation, right? Those are the ones out in the field actually doing the dirty work for him. Now he's going to say, I'm not paying, I didn't hire anybody, unlike in the mafia. But those people feel like he's kind of head of the family. And so they're going to go after anyone that threatens him. How is this happening? Well, yeah, take the cannoli. But if you think of it in that kind of a respect, if you think of it in kind of that mafia hierarchy, but a lot of times people are like, oh, that's, he didn't pull anybody else off. Like, no, they're self-identifying. They're self-identifying mafiosos out in the field, the foot soldiers doing it. And so those, again, not everyone, but those extremists are the ones putting in this kind of harassment and making everyone so afraid. All right, so here we go. The court's conclusion that the government's witness safety concerns are too speculative or generalized is misplaced. Yes, and I think she would feel differently if she wasn't part of the, if she was getting those kinds of threats. A court's duty is to prevent harms to the witnesses or the judicial process at their inception before they are realized and dysfunction envelops the trial. That's also very important. That makes sense given that the rule that the courts are helpless to act until witnesses have been intimidated, violence has been attempted, or a trial participant has been materially hindered from doing her job would gravely impair the basic function of the courts in the fair administration of criminal justice. And then we're citing the Nixon case here. Nor are the court's hands tied until evidence of direct causation materializes. To the contrary, a court's assessment of the threat to the court's functioning must be of necessity speculative, dealing with factors unknown and unknowable, and may appropriately be grounds both in record facts and common human experience. So, and I think a lot of this was quite a bit was quoted for Judge Engoron as well. Why wouldn't the Supreme Court see that Trump's foot soldiers were doing his dirty work? I think they have a good idea. I think they have a good idea, but again, we're not really, our system's not really set up to like deal with a reemergence of the mafioso. Everybody, like we barely took it down the first time. So, we're not really ready, and also we're not really prepared for a type of mafioso that's trying to take over the government either. If you think about it, Al Capone and all the guys, they had their own agendas. They had their fingers in everything, and they had judges and different political leaders, but they never tried to take over the government. They didn't want it. There wasn't a profit in government. But now we got a wise guy trying to take over the government. Didn't have put the Kool-Aid away. I feel like Kool-Aid's getting a bad rap, everybody. Just saying. All right, so here we go. In this case, common sense and common human experience teach that hostile messages regarding evidentiary cooperation that are publicly relayed to high-profile witnesses have a significant likelihood of deterring, chilling, or altering the involvement of other witnesses in the case. The government's not invoked concerns about witness safety or trial integrity in a boilerplate or speculative fashion. And then we're citing case law here. No, the Kool-Aid man. The fact that the government did not identify specific threats on the record did not make the risk entirely speculative, and direct threats are not a strict condition precedent to a district court's granting of a closure motion. Witnesses, agents, and judicial officers in this very case have been harassed, intimidated, and the further outing of additional witnesses will pose a similarly intolerable risk of turning their lives upside down. It's the only one that's profited from being POTUS. Well, yeah, exactly. I mean, that's what it's all about. That's the ultimate grift for him. In the old days, the mafia bosses were trying to, take care of the family, but he's just a family of one, just taking care of himself. Those significant interests in maintaining confidentiality greatly outweigh the disclosure interests of the defendants and the public. As noted, because the materials in question were attached to a discovery motion, no public right of access is attached. And then we have footnote number 2. Although the court previously denied as moot the Press Coalition's motion to intervene, their intervention would not change the analysis or the result. As noted, the only showing needed to justify the withholding of discovery materials is good cause. So that's all that's needed. So we have here, I do want to hit the Menendez case, everybody. So a recent decision in another district illustrates the point. In U.S. v. Menendez, the district court denied a motion to unseal discovery material, finding that the names and titles identifying potential witnesses, as well as the summaries of statements themselves, should remain redacted because they present information that could impact both the confidentiality and the course of the ongoing criminal investigation, in addition to affecting the privacy of potential witnesses in the upcoming trial. Preserving the integrity of the ongoing investigation and the privacy of undisclosed individuals with information regarding the ongoing investigation are emblematic of the types of higher value that ought to be preserved by redaction. The Menendez court did so despite the absence of a record of concrete harms to witnesses. Equivalent to the record here, this court should reach a similar conclusion and grant the motion for reconsideration. When in history have we had a criminal defendant receive such preferential treatment? Well, I've been thinking about that, everybody. And if you think about it, if I hesitate to say it, but if you look at the local level, there have always been these kinds of problems. What I think is happening here is that Trump is shining a light at the higher levels, and so people are actually seeing it. But if you think about just your local county, and you just have a magistrate, who knows everybody, and you think to yourself, who gets preferential treatment? Does anyone get preferential treatment? Are they treated equally? Are some people treated better than others? Maybe the pillars of the community, or the sheriff or whatever. I don't know. If you think back to old school times when everything was run by who you knew and how well you knew them, we're kind of in a bit of a similar situation where everyone's being careful with this highly explosive orange bomb. On the one hand, there's always been two-tier justice, haves and have-nots. True, exactly. At least two tiers. And so I think here we're seeing it. I think we've pulled back the curtain, everybody. And so you can see how if you are special, you are treated differently. If you have the money to go forward on appeals, if you have the money to pay for any attorney that is willing to take your case, what can it buy you? What can your position in the American society buy you when it comes to justice? And that's what we're seeing here. Yeah, yeah, sentenced to prayer by the judge. Yeah, yeah. Or if you think you're special. Well, right, right. And, I say that and it sounds so negative, but I just have to tell you, it is so much better than it used to be, everybody. Even just 10 years ago, it's so much better. I mean, we're going in the right direction, but it's a slow process. It's definitely a slow process. The price of doing business, yeah. I mean, and it didn't stop happening because, Barack Obama was president. I feel like a lot of people felt like, okay, it's all over, but no, it didn't stop happening. It just went underground. And so now it's like showing again. Oh my gosh, in my county, whatever you want. Yeah, yeah. He doesn't have the money. Well, I mean, he's got the power or the ability to. If you think about it, there were a lot of people that really didn't have the money but still fleeced the life, like Casanova, Mozart. This would not have seen the light of day. I know. Facilitating hazing it. Yes, exactly. Oh my gosh, VC. And that's not the only situation like that either. Supreme Court says he wasn't present January 6th, but they were carrying out his wishes. Yeah, I don't know that they have that. I'm not sure we've got a finding of that yet. We're still waiting on the Supreme Court's decision, but yeah, I think that's what we're seeing, everybody. We're seeing kind of this like preferential treatment that can happen in smaller rural communities. It happens every single day, but we're seeing it at a nationwide level, and we're shining a light on it. And that's what happens when you pull back the rug and you shine a light on it. It's ugly. It's ugliness, but it's the only way. It's the only way for change to occur. So we'll keep it on. And again, everybody, it's so much better than it used to be. It's so much better. All right. Reconsideration is warranted to prevent manifest injustice. So I think this is a really important piece. We've only got a couple pages left here. Reconsideration is also warranted because even under the legal standard that the court applied, it would be a manifest injustice to release the identities and statements of witnesses in this case. There's a well-documented pattern in which judges, agents, prosecutors, and witnesses involved in cases involving Trump have been subject to threats, harassment, and intimidation. Similar harms have already impacted a witness in this case, as detailed in sealed ex parte Exhibit A. So that makes me pause another moment, everybody. If we were to imagine all of this happening in a small town, all right, think about this going on in a small town where, Trump's like the leader of the town or whatever, like the top dog that pays everybody's, that has half the businesses in town. Imagine if you were a witness to his wrongdoing and you were part of that town, how you could possibly come in and testify and live your life normally. You just wouldn't be able to. You wouldn't be able to. Yeah, it's a lot. It's a lot. Yeah, 4,800. Well, yeah, exactly. But yeah, just picture that again. Picture that instead of this whole United States, that we're in a small community here, and his extreme minions, not all the minions, just the extreme ones, are out there and they're gonna chase you down. It's a scary prospect. And they are likely to befall many more if, as the court has ordered, their identities and roles in this case must be immediately made public. The court should not ignore this reality and expose the witnesses to such harm, particularly absent any defense argument for why exposure is justified. The government's redaction and sealing requests are narrow and well justified. Of the 70 exhibits attached to the defendant's motion to compel, the government sought relief as to 28. For only 17 of those did the government propose any redactions beyond personal identifying information. For 6, the government requested a sealing in full. And in connection with the government's opposition, the government sought sealing in full of 3 exhibits and limited redactions in 1 other. And as requested, corresponding redactions in the defendant's motion to compel. In its response, the government addresses each request below. So now we will get into, they go piece by piece and explain what's in each of these exhibits that makes it so that it needs to be sealed. So I found this particular part of this very fascinating. So we'll just kind of pick through this, everybody. All right, so Government's Exhibit A, C, and D and Defendant's Exhibit 2 are FBI 302 reports of interviews of potential government witnesses. They include career civil servants and former close advisors to Defendant Trump. Yikes. Civil servants and close advisors. The government's inclusion of and reference to these exhibits was necessary only to correct the false narrative that the defendants included in their motion to compel, but did not present a factual dispute requiring the court's resolution. So the only reason those were brought up was because of bad information in the defendant's motion. That's interesting. On the other hand, revelation of these witnesses' identities or the substance of their interviews with the FBI dangerously risks exposing them to the same type of harassment and intimidation described above and experienced by the witness in the sealed ex parte exhibit. Indeed, the witness whose statement appears in Exhibit D declined to have his interview recorded, citing the associated risks to him in Trump World. Ooh, Trump World! That's the small town, everybody, that we're talking about, of doing so. Yikes! Exhibit D also contains the witnesses' opinions about other potential witnesses and information about the case that other witnesses have revealed, but that are not public, as well as information about uncharged, potentially obstructive conduct by a defendant and speculation about witness tampering by an uncharged individual. To lay out exactly which pieces need what. Yeah, I know. But also, this is his record. He's making this record for the Court of Appeals, because the Court of Appeals is going to look back at this motion and review it. So he's being very thorough. Exhibit 51 is FBI 302 report that is Jencks Act material for a potential government witness. It cited two propositions that find support elsewhere and information the government is not seeking to redact. Citations for agents from various offices participating in the search of Mar-a-Lago, and 2, FBI coordination with the Secret Service, both available via Exhibit 52. There's no reason to publish this paradigmatic Jencks Act material. Okay, so paradigmatic, come on. Oh my goodness gracious. That's a bit much. Exhibit 59 is the Department of Energy memorandum discussed at some length in the defendant's motion. The only redactions the government seeks on this exhibit are the names of the author and recipient of the memorandum. These individual names are irrelevant to the court's resolution of the associated discovery request, and there's no reason to publicly expose them. Saying, I need this to come out of the record to go after some of the... Yes, exactly. All right, Exhibit 61, FBI 302 report of an interview of a potential government witness who worked for the White House Communications Agency. The witness provided extensive non-public details regarding enabling the sitting president to have secure communications and review classified information. Defendants cite the exhibit in support of their generalized discovery request for evidence related to secure facilities at Trump's residencies, but none of this sensitive information is necessary to resolve the dispute about whether the government is in possession of any additional relevant discoverable materials. All right. Exhibits 67 and 68 are transcript excerpts from interviews of potential government witness that collectively reveal details of the witness's interactions. This is so freaky, everybody. Seriously, if we had a mafia boss saying like, who told? Who's the one that told? Tell me who told. Like, everyone would be like, oh my gosh, don't tell him who did it. But like here, Trump's in the middle of this, like, I want to know who told on me. Like, come on, everybody. Ugh, it's very frustrating. Okay, relationship with certain defendants, and describe the process of finding attorneys for 2 other individuals, both of whom are identified by name and themselves potential government witnesses. The defendants cite Exhibit 67 for the undisputed proposition that the government questioned a witness about Stanley Woodward's representation of individuals in the investigation. The defendant's citation to Exhibit 68 does not advance any claim in their motion, and there's no reason to publish these excerpts except to place the witness in jeopardy. You say it. I can't. I am so frustrated sometimes. It's very frustrating. All right. Exhibit 69 is a 4-page excerpt of a transcript from a witness's grand jury testimony. The excerpt relates to the August 8th search warrant executed at Mar-a-Lago and includes non-public details about the layout of the private residence, such as the location of Trump's son's bedroom. Oh, hey, that's private. The defendants cite the exhibit to support the request for discovery pertaining to correspondence and communications about the Mar-a-Lago search. The transcript, which the government produced in discovery, is not necessary for the court to decide the motion, and there's no reason to publicly reveal this grand jury testimony, protected by Federal Rule of Criminal Procedure Rule 6E. Yeah, I mean, come on, they're even trying to protect his own kid more than he is. That's a lot. Exhibits that should be redacted. Here we've got some that are consistent or contain NARA emails, a list of discovery requests from the defendants, their letters from the government in response. Redactions in each are detailed in the appendix. Exhibit 33 is an internal FBI email that details a witness interview and provides the name of potential additional witnesses to be interviewed. Oh my goodness. 52 and 53 are internal FBI emails. And then exhibits as witness statements and the name of a person whom the emails indicate provides sensitive information to the FBI. And then exhibit 70 is an FBI internal email chain, which includes statements from multiple potential government witnesses about details relating to the search of Mar-a-Lago and a list of the names of FBI personnel who were present there. The government seeks to redact the list of names and specific statements made by witnesses about non-public details of the search. Defendants cite Exhibit 70 with its self-contained list of every FBI agent who was present for the search, a search that Trump has decried on social media as a raid by this people to establish the unremarkable propositions that FBI special agents were communicating throughout the search and that 2 DOJ attorneys were present for it. The court should not tolerate this barely veiled attempt to slide into the public record by first and last name the participation of over 20 FBI personnel in the search. Yikes. All right, in conclusion, the government asked the court to reconsider its orders and to stay the pending resolution on this of this motion, the requirement to submit newly proposed redactions. Let's just see that new requirement. I guess that's it. And the requirement to submit newly proposed redactions. Respectfully submitted, Jack Smith here, and then it's signed by these guys here. I'm afraid to even say their names, everybody. Like, I don't want to give too much more publicity. So let's take a look. We always like the visual aids. We do have a visual aid here in the appendix for the proposed redactions. So that's why I kind of skipped through those a little bit here. But let's just look at the redactions. Again, the other bits aren't included, of course, but they have included some pieces of this. So we have Exhibit 25. So they're proposing to redact the FBI code name of an unrelated investigation, the name of 3 witnesses, including the name of a witness this letter describes as having provided a recording to the government, grand jury activity involving a witness. Exhibit 27, they're trying to redact names of witnesses whose electronic devices were searched by the government, name of a witness who provided documents to the government. Number 29, again, they're trying to just redact everybody. The name of a private searcher hired by the defense, whose name prior counsel for the defendant had asked remained sealed from the public. Name of a witness which the letter indicates produced electronic devices to the government. Name of a witness who provided documents to the government and who is on the recording. Name of a witness which the letter indicates had text message communications with the government. Name of a witness who produced documents to the government. Name of witnesses who provided documents to the government. Name of witnesses about whom the government sought toll records. Name of witnesses who provided documents here, and then they're setting out exactly who in the paragraphs. And then name of a witness interviewed. So they're trying to get names redacted and an FBI code name. That's what they're asking. It doesn't seem like they're asking for a lot. You know, I mean, we redact stuff all the time. All the time we redact stuff, like less sensitive than names of people who could be gone after. So I don't know, everybody. What are our thoughts here? Again, this is that motion where Jack has come in, he has set his record out, he has explained why we need the redactions and what's going to happen if we don't get them. Seems odd to have to go to these lengths. Well, it is odd, and it's a situation again where we have someone who is doing everything possible to kind of draw everything out quite a bit. So it's extremely frustrating. I'm looking at the docket right now. So it looks like we have the government's conditional motion for leave to file. Okay, so we have a filing that just came down, everybody. Hold on. Let me print it. A filing just came down just today, so just within the last 2 hours, because it wasn't filed when I originally pulled it. So let me pull it. Required with his proven action. Yeah, I agree. A good new dirt. I know. Oh, exactly. All right, so let me go pull it off the printer, everybody. Jack has just filed a motion, a conditional motion. So let's take a look. Okay, everybody, it's hot off the presses, hot off the printer. All right, let's see what we have here. Jack wasn't watching the game. I don't think he does sleep. Or his whole team. I mean, he's got a team, and they're working hard. They're working real hard. So we have a document here. So this one, everybody, let me make sure I'm in frame here. Okay, so we have, let's just take a look. So this is a file, just came down within the last hour and a half, the last hour. We have the government's conditional motion for leave to file a surreply to defendant's reply in support of their motion to compel discovery. All right, this is getting ridiculous. Oh. All right, let's take a look. Let's take a look and see what's going on. Before we look to that, I do want to just make sure. All right, so this is all the filings that we've had here, everybody. So let's just take a peek. We have defendant's reply brief and further support of motions to compel discovery. So this was filed on February 9th. And, you know, I haven't really read through all of this. There's some bits in here like, you know, I think he calls Biden out on this. I mean, I don't know how he's relevant. That was not there when I started clicking. I know, Navy Vet, it's moving quick. His files. I figure between all of us, we'll stay up on it. All right, let's take a look here. We've got, this is Trump's motion, all right? So President Trump has made prima facie showing of selective, vindictive, whatever. Evidence of political animus is discoverable, irrespective, whatever. An order defining the prosecution team is necessary, all right? So this is where he's like, every single person in the Department of Justice and in Washington, D.C. needs to be included. It quotes the Biden interview. Okay. Special counsel's office failed in their efforts to minimize the significance of discoverable events during the investigation. All right. The court should reject vague privilege-related claims, misrepresentation made by special counsel's office concerning the production of forensic images. Defendants Nada and De Oliveira request for disclosure of non-classified discovery. All right, so that's just a quick review, everybody. But I do know that there is some discussion in here regarding, you know, the report that just came out. You all know the report I'm talking about, right? The report from the special prosecutor on Biden and the classified documents. Everyone's familiar with that. It's a national security meme tweet. Oh my goodness. All right, so here's the special counsel's report. I've not had a chance to read it yet. I do have it. Oh, this is a nightmare. This is almost a 400-page report from the special counsel regarding Biden. And you best believe I'll be reading through this. I can't have this pass me by. So we will take a look at that when the time's right. But let's get back here. I know. So yeah, let's get back here. All right, government's conditional motion for leave. So let's take a look and see what we've got here. I know. Oh, it's a lot. Oh my gosh. It has pictures. Yeah, there's pictures. Let's just take a peek and see, because I saw that there were pictures in there too. So Mr. Biden with a manila envelope at the breakfast with senators in January 29th of 2015. Oh no, he's got an envelope. There's an arrow pointing to the envelope. What is happening? All right, here we have view from the front office towards the staff assistant's desk. I don't see any arrows on this one. I don't know, everybody. Okay, here's one photo of the interior of a small closet off of Mr. Biden's office, taken November 3rd of 2022. But I don't know. I mean, are there classified documents in here? I know the VP has an envelope. No! All right, so I'll have to take us through this whole thing. Oh, here we go. Oh, look at this. This looks like any professor's office, by the way. Photos of a storage closet at the Penn Biden Center, March of 2021. So we do have some pictures. Here. But, again, I'll have to take some time to go through that. And again, lest we forget... Lest we forget, let me see here. Okay, this is Mr. Trump. Like, what are these? This is Mr. Trump. And remember, too, Mr. Trump didn't give them back. This is Mr. Trump again. Biden's were at least stacked up. Fancy coat hanger. Oh, this is the bathroom. Remember that? Oh my gosh, these dingleberries. All right, so here we go. And also, when they said, hey, Biden, can we have our documents? He's like, sure, here you go. And Trump was like, no, you can't have them. So show the stage. Yes, so let's take a look. Oh yeah, here's the stage. So it's different. I need to clean my closet now. Oh, I know, everyone. I know, dueling boxes. I know. Quality bathroom reading. Right. So, we've got some pictures. Oh my gosh. So it's going to take some time to go through that. Where's Pence report? I know. I'm waiting for Pence's photograph. I'm going to make a scrapbook of classified documents. But everybody gave them back except for Trump. Like, man, that guy, if he would have just given them back, he would have saved himself a lot of trouble. All right, here we go. I'm just going to read through the beginning here. Let's take a look. On February 9th, the defendants filed a lengthy reply in support of their motion to compel discovery, which I just showed you, relying heavily on factual assertions, legal citations, and public domain materials that were wholly absent from their initial motion to compel. Ouch! And their classified supplement, their reply for the first time claims that the defendants had made a showing sufficient to warrant discovery, a hearing, and ultimately dismissal, based upon a claim of selective and vindictive prosecution. You're not supposed to put that in a reply brief. Why was that in a reply brief? That should be like in a regular motion. That doesn't seem like the right motion to me, but all right. That was that was procedurally improper. Okay, it wasn't just me. I thought I was going crazy for a minute, but I wasn't. Okay, so that wasn't procedurally correct. I don't know. Say that they made requests. Yes, they did. Yeah, they did. Okay. So that was procedurally improper. All right. Good for me for noting that. That's funny. Arguments and factual assertions not presented in an opening motion and raised for the first time in a reply brief are not properly before the court. That's true. That's legal research and writing 101. And the court should not be asked to decide matters that have been neither properly raised nor fully briefed. That principle should apply with particular force here, since the defendants have indicated they intend to file a separate motion making precisely such claims regarding the selective and vindictive prosecution, and will do so in less than 2 weeks. Sound judicial administration counsels the court to disregard what is even happening here. Like, this is just basic procedure, everybody. The new factual allegations and legal arguments raised for the first time in the defendant's reply brief and direct the defendants to raise their arguments in a motion that they have signaled they will file by February 22nd. To the extent the court wishes to consider their new claims at this juncture, however, the government requests leave to file a surreply to address the new factual assertions and arguments. How do we have new factual assertions? Oh my gosh. All right, let's take a look. Here's number 1. The government has conferred with the defendants who oppose this motion. Shocking, everyone. Shocking. I'm shocked. And request an opportunity to respond. If the court grants leave, the government requests permission to file its surreply within a week of the court's order. The government's proposed surreply would not address any matters that were properly addressed in the defendant's reply. So what the government's saying here is that Trump has raised a whole bunch of new legal defenses and issues in his reply brief, which is improper filing procedurally. And everybody knows that. You can't raise new issues there in your reply brief. You can file separate motions to your heart's delight, but you can't just toss it into a reply brief. That's just improper procedure. Here's the background. On January 16th, defendants filed a 64-page motion to compel discovery, which we've read. The defendants sought discovery in 6 categories of information in 2 uncategorized areas, which was hilarious. This is where we had the chart, everybody. Government's response describing defendants' discovery requests, but nowhere in the motion to compel did the defendants argue that they were seeking discovery to advance a claim of selective or vindictive prosecution, or cite the stringent legal standards that restrict discovery requests on such claims. The defendants instead sought discovery under Rule 16A of the Federal Rules of Criminal Procedure and Brady concerning what they believe to be improper coordination between prosecutors and the National Archives and Record Administration, so NARA, and on what the defendant described as evidence of bias and investigative misconduct. So those were the issues that they had originally brought up. So those are the issues that they kind of need to stay with. All right, everybody, I got to add my battery pack. Just a moment. Oh, my goodness. Okay, here we go. Just one moment. Oh, thank you. All right, there we go. We're back on. Back on. Game on. All right, so yikes. All right, so all right, they're going in and they're saying, hey, he's filing a whole bunch of new stuff in his reply, which you're not supposed to do procedurally. In response, the government explained that these discovery requests fall outside the ambit of Rule 16 and the Brady Doctrine because they seek information that's neither material to preparing the defense for purposes of Rule 16 nor material to guilt or punishment for purposes of Brady. Now, Brady is the rule where we have all prosecutors have to give any exculpatory evidence over to the other side. The government further explained that notwithstanding the defendant's failure to cite the relevant standard and precedent, the defendant's request effectively constituted a request for discovery to support selective prosecution claim. To justify such a request, the government pointed out the defendants had to satisfy the rigorous standards set forth in U.S. v. Armstrong. Is this where Cannon said Trump can have 2 weeks, but the government had to respond within a day or two? I don't know. This was just filed within the last hour. In the last 2 hours. So I'm not sure yet. This is my first reading of it also. We'll see what happens. But no, she at this point, Cannon has requested briefs just on the redaction request by the government, which is very odd. Here. So rather than press such an argument in a future motion, the defendants in their reply brief for the first time claim that they made a prima facie showing of selective and vindictive prosecution. And the new claim is not offered in passing or in a brief comment. Instead, it's the lead argument running from page 1 to page 12 of their reply, over which the defendants advance a slew of new legal and factual claims. Despite never citing Armstrong or the related 11th Circuit precedent, which is where they're at, in their motion to compel, the defendant's reply now purports to lay out the governing standards for selective and vindictive prosecution claims. But in fact, the defendant's resuscitation of the applicable standard is incomplete and misleading, as they cite the requirement from U.S. v. Smith. Oh, goodness. But mask behind an ellipsis the full articulation of the requisite standard. Come on with these words, everybody. Come on. As the full quote from Smith makes clear, the 11th Circuit requires much more. To satisfy the discriminatory effect requirement, the defendants would have to identify similarly situated comparator who engaged in the same type of conduct. Let's skip down here, all right? They're talking about the standard that here he's using the wrong standard, the Smith standard instead of the Armstrong standard. And the defendant's reply does not simply raise new legal arguments, it also advances new factual claims that they should not be permitted to raise for the first time in a reply to which the government has no opportunity to respond. Specifically, the defendants attempt to draw comparisons between defendant Trump's conduct and the conduct of other executive branch officials who were not prosecuted, including, here we go, President Joseph Biden, as described in the report released on February 8th of 2024 by Special Counsel Robert Hur. Okay, that's this. I haven't read that yet. Haven't made it all the way through. Former Secretary of State Hillary Clinton. Oh my gosh. Former Vice President Mike Pence. Yikes. Why are they including that? Oh my gosh. Former President Bill Clinton. Former FBI Director James Comey. Where's Obama? The defendants advanced none of these legal or factual claims in their motion to compel, despite the fact that all but one of them were known to them before they filed their motion. So much homework. True story. Yikes. Argument. The defendants failed to advance a selective or vindictive prosecution claim in their motion to compel, and they are precluded from belatedly pressing any such claim in their reply brief. This is just procedurally a nightmare, everybody. This is ridiculous. They should instead be required to address their new claims in the motions that they have advised the court they will file on February 22nd. So again, Jack's not saying you can't bring these issues, you just have to file it in the proper motions. If the court nonetheless wishes to entertain such a claim at this juncture in the context of a motion to compel discovery, under Rule 16 and Brady, the government respectfully requests the opportunity to respond to the defendant's new legal and factual arguments in a SIR reply. So a SIR reply, okay, usually we have a motion, okay, then we have a response, is that right? We have a response, and then we have a reply, and then usually that's the end of it. You get 3 bites. That's typically the end. In some cases, you can have a SIR reply. So that's what he's asking for. He's saying, hey, he had an original motion with his issues. We responded. Now he brought up a reply with a whole bunch of new stuff that does not fit with his original motion. He raised a whole bunch of new stuff. So we want to have an opportunity to have a proper reply to all this new stuff that he's bringing in. All right. So they're talking about the applicable law and the discussion again going into how his brief is incorrect. So here's the conclusion. The court should not consider facts and argument raised for the first time in the defendant's reply in support of their motion to compel discovery. In the alternative, the court should permit the government to file a SIR reply to be filed within a week of the court's order, limited to newly advanced facts and arguments. So there we have it. Again, everybody, the order is supposed to be a motion. So a motion is when you set out your arguments, you're asking the court to do something, all right? You're asking for some kind of movement. Here, they were asking the court to compel the government to give them discovery, all right? So they had all these discussions about who all was involved in the team and anybody that knew anybody should be included and blah, blah, blah. That was already set out in their 70-page brief, all right? Then the government gave a response, and their response replied to each of their questions. This was when we had the dueling motions, when I pulled out what Trump requested and then what the government said was reasonable. Like, we don't even have this stuff. We don't even know what you're talking about. So that was their response regarding their motion to compel discovery. Now they have filed this reply. And in this reply, they're now including classified documents from other former people that was not included in their original motion, that wasn't mentioned in here, and citing a report that came out after they even filed their motion. So now we have this filing, everybody. So we're not going to call this a surreply yet, but there's this filing now by the government, and they're asking to be able to file a surreply to all of these new pieces of information that he's asking for here. This is ridiculous. This is bonkers legally. If you look at it from a legal procedure point of view, like, this is what happens in, like, moot court. Like, you don't just file you can't just bring up new stuff in your response or your reply. Like, you have to file a new motion, and you can. There's no reason why he can't bring up these new issues that he has. Go for it. Hey, Mr. Trump, go for it. File to your heart's delight. But you have to file properly. You can't just add your stuff in here. It's very similar to what's going on with all of the privacy issues under the SIPA case in Florida, where he's just adding on all of this information that's supposed to be protected instead of filing things properly. Are you sure Trump attorneys are qualified? No. No. TV law shows it's even worse. No, I have no idea if his attorneys are qualified or not. I have no idea. I thought they would be, but who knows? Who knows anymore? We had Judge Kaplan saying to one attorney, like, are you even licensed here? And that attorney was like, no. So I don't even know what's happening anymore. It's a game. It's a game, yeah, but also, like, who's doing this? Like, come on, everybody. Like, this is basic. This is just basic court protocol, basic 101. You file a motion. He needed to just file a new motion. Make your reply short and brief. We don't even need a surreply. Just make your reply short to the response. And there wasn't much in there that they needed to really reply to. It wasn't that long of a brief. And then make another motion. Do another motion, dude. Do a fresh motion. Like, get a fresh sheet of paper out and file it. They're just doing what Trump wants. I don't know. I mean, he's not going to know, like, how the orders of motions and stuff, right? His attorneys probably have been told to just keep filing motions, keep me out of court. Now that could be. You can whack a hair too. Oh my goodness. Everything to waste time. Yeah, we actually seeing real time how Trump's always treated the courts. Yeah, I think that's very true, Cynthia. I think that's very true. But, it's one thing if you've got a real green attorney that's only been out for a couple of years and this is their first big case, and so they're kind of screwing the paperwork up a little bit. That's one thing. But a case of this magnitude where, we've got a judge who's like, and all mavericky out, going like on the desert with the horse with no name style of judicial review. So we've got this, yeehaw going on. We don't need this kind of silly business occurring on top of it, because who knows? With Judge Cannon, she might be like, sure, go for it. Go. Yeah, let's bring this all up. I rule on it. Yes. Like, I agree with everything you said in your reply. No, sir, reply. I agree. This is madness. This is complete anarchy at this point. At this point, Judge Cannon, Judge Cannon is just, we don't know what she's going to do. We don't know. I don't know. Maybe she doesn't even know. Maybe she doesn't even know what a SIR reply is at this point. I really am confused about what she's doing. She'll be like, why do we need a SIR reply? It's fine. Everything's fine. Yeah. Let's charge Biden. Why not? Like, oh, for goodness sake, you're a judge. She's a loose cannon. I prefer the term maverick. She's got paperless order. Hitch? No more paperless orders. Judge Cannon, stop paperless orders. Stop it. My bingo card went null and void because the statements are fluid. Can't wait to see her response. Well, let's just refresh since we've had so much. I mean, this is just filed in the last 2 hours. Come on. There's stuff going on in the world that's not this. All right, this is the last thing that's been filed. That's more politically correct. I don't know. He's not even paying his attorney's fees. He's probably got dirt on him, all right? I said it. If we're in mafioso land, let's just go the full way. Let's go. The only reason they're working is because they don't want to be swimming with the fishes, Oh my gosh. What's a SIR reply? Exactly. Exactly. You want to do what? All right. So again, remind everybody, this was just filed, the government's conditional motion for leave to file a SIR reply to defendant's reply in support of their motion to compel discovery. Like, even the title of this motion is like, this should not be happening. Oh my goodness gracious. It's a lot. All right. Well, with that, everybody, I will need to bring our sub chat live to a close. Oh my goodness gracious. It's been quite the night. Quite the night, everybody. All right, so friendly reminder about what we've got going on here. I don't know. I feel like we're giving Kool-Aid a bad name. Can we say Tang? I've always been worried about Tang, right? Didn't they take that to space? We don't know what happened. All right, so we've got Monday, tomorrow, everybody. If Mr. Trump wants to file an appeal for the Court of Appeals out of the D.C. Circuit regarding the immunity decision, right? That's due tomorrow. So that is due tomorrow. He's got to file it tomorrow. That's the deadline. I will be coming in and going through all of the updates on the Engoron situation with the New York civil fraud case, with the emails and the letters that have been going back and forth. So that will be my 7 o'clock Central. The Tang. I know, but I don't know. I feel bad for Kool-Aid. I mean, that was a tough break. Oh, thank you. So 7 o'clock Central, everybody. I don't know what's going to go on in Florida. We're just going to put Florida aside for now. We have a big day on Thursday, everybody. We've got the omnibus hearing for the New York criminal case. So the hush money case, the campaign fraud money case, whatever you want to call it. The two ladies doing their stuff, payment case. That's going to be going, hearing for that on Thursday. We also have the disqualification hearing for DA Fani Willis. That is set up for Thursday. I don't know if that's still going to go, everybody. We still have some very compelling motions that have been filed on whether or not to even have that hearing. So we'll see what Judge McAfee rules, if we even have that or not. But that is set for Thursday. And then we also have the Blessing Game case. If they're wanting to do an appeal up to the Supreme Court, that will be here with SCOTUS as well. So the Blessing Game case is where we have the Capitol Police suing Mr. Trump for his actions on January 6th. There were a couple of pieces that were denied out of that, several pieces that were agreed upon. So I'm not sure if they're going to appeal that or not, but we will see what happens. Will the omnibus hearing be live streamed? I don't know. I do not know. I'm leaning towards probably not. And because there's some security issues, so I think that would be probably a problem. Right. So, we had motions filed regarding Miss Fani Willis and her whether or not she should be disqualified from the RICO case in Georgia. Everyone knows my opinions on that. So the hearing Judge McAfee set regarding That is set for Thursday, but we don't know whether or not that's actually going to go. So what days will I be live? So I will be this week, everyone. I will probably do a Monday, Wednesday. I'm probably not going to be back on Thursday. We'll see if I'm on Thursday, but usually Monday, Wednesday, Fridays has been what's been working for me lately. So definitely Mondays, and then I'll give you a heads up on what the rest of the week will look like. My schedule's just not quite as firm as I would like it yet. But right now I'm doing a Monday, Wednesday, Friday, and I'm doing 7 o'clock Central Time, although I do bonus lives that are kind of sprinkled throughout the week if something really interesting and fascinating happens. So we're waiting on the Judge Engeron decision out of the New York case, so that will be pretty big once that drops. That'll be a huge one. But right now we're really going to be waiting on whether or not we have filings on that immunity case for SCOTUS. And if SCOTUS even takes it, I don't know. I don't know if they will or not, but we will wait and see. So thank you for all of everyone who came by tonight to hang out with me and get an update. We will definitely be doing an update on the Georgia RICO case this week. And again, we're paused in DC. We're going to see what's going to happen exactly after tomorrow. We will see if there is a filing for a writ of a certiorari, and we'll see if the SCOTUS picks it up or not. I'm not sure if they will, but we'll see on that one. Other than that, though, we'll just kind of take it one day at a time, everybody. So have a wonderful night. Thanks for coming and spending time with me again for my special Sub Chat Sunday. All of the rest of my lives, I make sure to open up my comments. So take care, everybody. Thank you for joining me. Have a wonderful rest of your Sunday night, and I will be back again tomorrow. So have a great night, everybody.